A Will, Power of Attorney, and Healthcare Directive Information Guide, presented by Thompson Dorfman Sweatman LLP. Today we are going to speak about estate planning and why not having your affairs in order can have negative consequences for you and your family. There are 3 legal documents that all adults should consider having: a will, power of attorney, and a healthcare directive. We're going to discuss the importance of having a properly drafted will, power of attorney, and healthcare directive, regardless of the value of the estate. So, to follow our agenda today, we will discuss the following documents: what is a will and why you need to have one, what is a power of attorney and the importance of having one, what is a healthcare directive, also known as a living will, and then we will deal with closing remarks. Before we proceed, the following presentation is not legal advice, but rather a general overview of information with respect to estate planning. If you have specific questions about your estate, please contact a lawyer. Many people in Canada do not have a will or power of attorney. Some of the main reasons for this is that, first, people simply do not wish to confront, talk, or even think about death and its inevitability. And second, dealing with estate planning is an expense people rather put off as long as possible. Unfortunately, this is a dangerous combination because the person that fails to plan does not see or experience the consequences of not having had these important documents. Almost everyone has an estate. An estate can be comprised of the money you have in your bank account, your investments, your real property, your personal items of sentimental value. Having done advanced planning with respect to your estate allows you to decide what happens with your estate rather than leaving it up to the law. Having done some planning will also help to avoid family conflicts, delays in settling the estate, and legal challenges or other issues arising after death. The only effective way for you to control what specifically happens with your assets and your estate is to have a properly drafted will. So what is a will? A will is a written document that controls the disposition or distribution of a person's property after death. There are 2 different types of wills. First is a holograph will, and the second is a formal will. A holograph will is written entirely in the maker's own handwriting. It is also dated and signed in the maker's own handwriting. What we must remember about holograph wills is that you cannot type them up on a computer, print them out, and sign them. Such a will would not be considered to be a proper holograph will. Second type of will is a formal will. These wills are in writing and are signed by the maker. The signing of the will is witnessed by 2 persons. There are also other legal formalities that formal wills have to fulfill. Having a will does not prevent you from dealing with your own property, because a will only takes effect or speaks at the moment of your death. For example, if a person signs a will gifting a cottage to a relative, this property can be sold or gifted to someone else during the person's lifetime without the consent of that relative. Upon the person's death, the will would be read as if no gift of the cottage is contained within it, and the relative would obviously not receive the cottage previously disposed of. So, signing a will does not prevent the disposal of assets during a person's lifetime. Some reasons to have a will. A will helps ensure personal wishes are followed with minimum expense and delay. If you do not have a will, there is a statutory plan for disposition of your assets according to the Intestate Succession Act, which follows a rigid formula. Under the Intestate Succession Act, there is no provision for any charitable wishes for organizations you have supported in the past, or for any other similar organizations that you supported in the past and you wish to benefit. If a person dies without a will, his or her estate will be distributed according to inflexible provisions of the law with no consideration for the person's wishes. The law provides benefits to close relatives only, and the person's property will not be provided to friends, distant relatives, or worthy causes supported in the past. Remember that the distribution of personal effects and family heirlooms, as well as debts owed to the person, may also be dealt with in a will. Another reason to have a will is that trusts may be established in favor of a minor or a person under disability. A will can provide specific instructions for the establishment and administration of the trust. A will is also a way for a person to clearly state his or her wishes concerning guardianship of children. Although a court must make the final decision on guardianship of children, instructions in a will may be taken into account as a persuasive statement of the parent's preference concerning who should take care of the children. Remember that making a will is an active consideration for your family and loved ones. A will makes things easier for surviving friends and family members who are already suffering emotionally. Another reason to have a will is that you save some cost. If a person dies without a will, the court will require the appointment of an administrator to settle the estate, which in many cases can be more time-consuming and more expensive. The powers of an administrator are also limited and not as broad as you can allow for in a will. Other reasons to have a will. A will can help arrange property to maximum benefits of the estate by deferring capital gains and tax obligations. A will may also help ensure the succession of ownership and control of specific estate assets, including houses, cottages, and businesses. Although it is possible to create a valid will without the assistance of a lawyer, caution should be exercised in doing so, since a lawyer has the expertise and knowledge to provide a person with a will that works best for him or her while protecting against consequences that may be unknown to someone who does not have a legal education. Since a will is one of the most important documents a person will ever sign, one should seek professional advice in preparing it. One small mistake can cost the estate a great deal of money or even invalidate the entire will. There are some general causes that are included in most wills, but the contents of a will are really dependent on your personal circumstances. Some of the general clauses often found in wills are appointment of an executor, a clause with respect to payment of debts, a clause with respect to distribution of personal items and specific gifts, a residue clause, which refers to property that's not specifically distributed in the will, and a clause dealing with the powers of the executor. Take 3. When you are making your will, you will want to gather information and plan out your wishes. You will want to gather information by listing all family members and relationships of significance to you. Then you'll want to list all of your assets. Then you'll want to list all of the assets that you jointly own with other people. You will want to consider the contents of your will and who will be your executor. You want to gather information on your beneficiaries in order to identify them. And then you're going to want to discuss your plans with your family. You might also want to consider giving to a charity or other organizations that you supported in the past. These might include the MS Society, the Winnipeg Foundation, Heart and Stroke Foundation, Lung Foundation, Cancer Society, or any other charitable organization that you would like to support. As mentioned previously, a holograph will is written entirely in the maker's own handwriting, dated and signed. And for a formal will, the documents must be in writing. They must be dated and signed in the presence of 2 witnesses, and all the people must be in the room together at the time of signing. For both a holograph and a formal will, the maker of the will must have testamentary capacity. This is one of the main reasons to get a lawyer to assist you with preparation of a will. It is part of a lawyer's job to assess the testamentary capacity of the maker of the will and document it, so that if there is ever a challenge to the validity of the will, the lawyer can present evidence confirming the testamentary capacity of the maker of the will. Another important thing to remember when making a will is that witnesses cannot be the beneficiaries or the spouse or common law partner of a beneficiary of your will. Witnesses must also be competent. Caution. In many cases, pre-printed will forms or will kits do not fulfill the needs of the person writing the will and do not allow for the flexibility required by your personal circumstances. You also have to make sure that such forms are completed and executed correctly and ensure that the forms actually reflect your wishes. For example, if part of the form is pre-printed, part of it is typed, and another part of it is handwritten, someone might be able to contest the validity of the will by claiming that part of it had been forged. This is because any change in a will leaves room for doubt as to whether the testator, who is the person making the will, made the changes, or if somebody else made those changes. People tend to cross out, delete, or add words to these pre-printed forms. It can be very difficult to determine who made these changes and why they were made. This problem also puts the will in jeopardy of being contested. As mentioned before, pre-printed forms are general forms and do not take into consideration the specific needs of the maker of the will. As a result, property may be accidentally left out, beneficiaries might not be included, or other mistakes may happen. Changes and revocation of your will. A will should be reviewed every few years. It doesn't mean that you have to change your will every few years, but you should take it out and periodically review it and make sure that it still fits your circumstances. If it does, put your will back aside. If it doesn't, then attend to the changes that are needed. A person should also review and revise a will as necessary upon the existence of new circumstances, including marriage, separation, contemplation of divorce, and the birth of a new child. A minor change to a will can be made by a separate document called a codicil. You must remember that generally making a new will revokes a prior will, as the new will generally includes a specific provision regarding revocation of prior wills. A will can also be revoked by destruction of the will or damage. Caution. Divorce does not revoke a will for all purposes. While generally speaking, a marriage revokes a will. If you went through a divorce or marriage, you should consult a lawyer regarding making a new will to ensure that your testamentary desires are captured by a will. If you went through a divorce or marriage, you should consult a lawyer regarding a new will to ensure that you have a valid will in existence. Some closing remarks on wills. Don't wait till it's too late. Planning for your future begins as a young adult and should evolve as you age. It is not something you should generally consider holding off until you approach your senior years. In life, anything can happen, so you should plan for the what-ifs. Some do's. Do consult a lawyer. Do review your will on a regular basis. Do keep your will in a safe place, often a safety deposit box or in a vault at your lawyer's office. Do let your executor know that they have been chosen and where to find your will. And do be aware that legislation may affect and impact your testamentary wishes. Some don'ts. Don't wait until it is too late to plan your future. Don't sit back and think everything will work itself out. Don't forget about tax implications, especially if you have substantial assets in your estate. And don't rely on will kits as the means to distribute your estate. Estate planning documents can be prepared by a lawyer for a reasonable price. Planning your future should not wait until later in life, because planning will ensure your wishes are followed and save your family extra expense and aggravation. What is a power of attorney? Well, it's a written document that allows someone to manage your legal and financial affairs, but not healthcare or medical treatment decisions. A power of attorney is only in effect during the lifetime of a person. A power of attorney has no authority after death. Some specific terminology. A donor is a person who is giving the power. An attorney is the person who is receiving the power, i.e., the person who will act on your behalf. An attorney in these circumstances does not necessarily mean a lawyer. Different types of powers of attorney. There's an immediate power of attorney, and these come into effect immediately upon signing. And the springing power of attorney. These come into force on the occurrence of a specific event, and they're most often used to plan for extended absences or the possibility that the donor has become incompetent. A power of attorney can have a specific purpose and be limited to that purpose, such as to sell a specific property or to do some certain kinds of banking. There's also an enduring power of attorney, which is a type of power of attorney that continues to be in effect notwithstanding the future incompetence of the person. Some reasons to have a power of attorney. You will be able to select the person who will be the attorney and who will act on your behalf. This allows you to choose who will manage your property and financial affairs for a specific or extended period. It also helps you to plan for a time when you may not be able to make decisions about your property and financial affairs. A power of attorney does not mean that you have to give up power. You can make the power of attorney come into effect upon your incapacity only, or you can even indicate when you wish for it to come into effect. A power of attorney will provide peace of mind for yourself and for those who care about you and care about your wishes. A power of attorney will also avoid the time and expense of a committeeship application. A private committeeship application will have to be brought to court when an individual is unable to look after his or her financial affairs and where there's no power of attorney in place. So what are the contents of a power of attorney? Well, the first consideration will be who will you name as an attorney, and whether or not you wish there to be one or more attorneys acting. It is recommended that when you name an attorney, an alternate attorney is also named, so that matters can still be handled if the first named person is unable or unwilling to act. As a general rule, it is a good idea to have more than one attorney, since this individual may become unavailable, unwilling, or unable to act. However, having too many attorneys may cause problems, especially if the attorneys have different beliefs and philosophies concerning financial issues. Although you may name your spouse or common law partner as an attorney, he or she cannot act as the attorney with respect to the shared residence in which both you and your common law partner or spouse reside, often called a homestead. This is why it is important to name an alternate. The next consideration is whether you're making a general or specific power of attorney. You need to decide which, because it will affect how broad or limited the authority of the attorney will be. You can provide as much or as little power and authority to your attorney as you are comfortable with doing. However, you should make sure you provide enough authority to your attorney to enable the attorney to look after your affairs when you are unable to do so. This is an issue you will need to discuss with your lawyer. The power of attorney should also indicate whether it comes into effect immediately or at some point in the future. It should also indicate whether it is an enduring power of attorney. Other considerations for a power of attorney. Will you provide any individual with the authority to request and receive an accounting from your attorney by naming that individual or individuals in your power of attorney? Another consideration, will you want your attorney to be paid for acting as attorney? All of these considerations are very important and should not be taken lightly. With respect to execution of your power of attorney, you must remember that your power of attorney must be witnessed by a qualified person, which means that the power of attorney must be signed and witnessed by one of the following individuals: a lawyer, a notary public, an RCMP or municipal police officer, a physician, a judge, justice of the peace or magistrate, or a person authorized to solemnize marriages. An enduring power of attorney is a very powerful document, and therefore it is required that one of these professionals witness the signing of the document in order to protect against the forced or inappropriate execution of these documents. Other requirements for a power of attorney include that the donor must be mentally competent and that the power of attorney must be in writing. If you wish to terminate a power of attorney, you should advise everyone who was previously provided with a copy of the power of attorney. Some of the circumstances under which a power of attorney terminates include the custody of the estate of the donor is taken over by the public trustee or other person appointed by a court under the Mental Health Act. The donor becomes bankrupt. The attorney becomes bankrupt or mentally incompetent or dies. The donor dies, or the attorney renounces the appointment and gives notice of the renunciation to the donor. The cost of making a power of attorney is insignificant compared to the cost that can be incurred to obtain a committeeship appointment, especially if there are family members or interested parties who may not get along. Closing remarks. Some do's and don'ts. Do consult with a lawyer. Do give careful thought to the attorneys that you choose. Do talk to the proposed attorneys and anyone you name to receive accountings before signing the power of attorney. Do inform those who need to know, such as your attorney, a bank, or family, once the power of attorney is signed. A power of attorney has no use if no one knows of its existence. Some don'ts. Don't sign without getting legal advice. Don't sign under pressure or if you are unsure. Don't name someone you can't trust or who isn't a good money manager. And don't use a joint bank account instead of a power of attorney. What is a healthcare directive? A healthcare directive is a written document that allows you to express your wishes on the level and type of medical treatment that you wish to receive in certain circumstances. These are often called living wills. Some terminology. The donor is a person who is giving the instructions, and the proxy is the person that you've named in your healthcare directive who will be making the decisions on your behalf. There are two main functions of a healthcare directive: naming a proxy and expressing your wishes around healthcare treatment. You may do one or the other or both. Some reasons to have a healthcare directive. You will be able to select the person who will be your proxy, and it's as an act of consideration to your family members. Some reasons to have a healthcare directive. You'll be able to select the person who will act as your proxy, and also as an act of consideration to your family members, since they will not have to guess at your wishes. Executing your healthcare directive. Healthcare directives are recognized by Manitoba law under the Healthcare Directives Act. A healthcare directive must be in writing, signed, and dated. The healthcare directive must be in writing, but it does not need to be in any specific form. The Manitoba government has created a form to assist people in making healthcare directives, but you do not have to use this form in order for your healthcare directive to be valid. The maker of a healthcare directive must be over the age of 16. The maker must also be mentally capable of giving informed consent to treatment. And finally, the healthcare directive must be brought to the attention of your healthcare providers. It is also extremely important that the healthcare directive is accessible and easily found, since your wishes cannot be followed unless they are known. Consider where you'll keep your healthcare directive so that it can be found and brought to the attention of your healthcare providers when it is necessary. Some do's. Do talk about your wishes with both your proxy and your family. Do give copies of your healthcare directive to your proxy, your physician, and your family if it's appropriate. Do talk to your physician if you intend to include statements about medical treatment. Do use clear and concise language when expressing your wishes. Lawyers are not doctors, and while your lawyer can help you as you consider making a healthcare directive, it is important to remember that lawyers are not healthcare professionals. Your doctor should help you determine the correct language to use in your healthcare directive in order to accurately reflect your wishes. Some don'ts. Don't put the only safe copy of your healthcare directive in your safety deposit box or anywhere that it cannot be easily found. Don't keep your healthcare directive a secret. Don't use legalese or jargon when expressing your wishes, and don't use pull the plug type phrases. Some closing remarks. Many seniors are including their healthcare directive in their emergency response information kits. These kits are meant to be posted on your fridge. They can be obtained through most senior centers. The kits are extremely helpful if emergency responders ever attend to an emergency at your home. You may also want to consider keeping a copy of the healthcare directive in your car or your purse. Conclusion. Don't wait. Later might be too late and it may get more expensive. Remember that estate planning documents can be prepared by a lawyer for a reasonable price. Planning your future should not wait until a specific stage in your life, as planning your future will ensure that your wishes are followed and save your family extra expense and aggravation. Be aware of the potential for financial abuse. There can be pressure or undue influence to sign a power of attorney, a will, a healthcare directive, or other financial and legal documents such as transfers of land or joint bank accounts. Pressure or undue influence may be prevented or minimized if you consult a lawyer to ensure that proper documents such as a will, power of attorney, and healthcare directive are in place. Ways to keep legal costs down include preparing information in advance to give to your lawyer. For example, consider who will be appointed as the executor of your will and alternate executor. List all your family members and relationships of significance. List all of your assets and jointly owned assets. Gather information on your beneficiaries. And consider the specific contents of your will. For example, if you are married or have a partner, what is supposed to happen if your spouse or partner dies before you? Consider also the distribution of the assets of the estate in various circumstances. What if some of your beneficiaries have died? Who gets certain aspects of your estate in those circumstances? Planning all of this in advance will help to keep your legal costs down. This concludes a will, power of attorney, and healthcare directive information guide. Thank you for joining us.